and development, and in intellectual property management in the field of active pharmaceutical ingredients. He joined in Dr.Reddys Laboratories Research and Development team in 2004. He worked in R&D for 5 years, then moved to Intellectual Property Rights Department, and now working as a specialist in IPR department in Dr.Reddys Laboratories, Hyderabad. He has 5 articles, 8 patents, and so many international journals. Actually, it is SAR's simple profile, but not complete profile. Now, I welcome today's speaker, my friend, Dr.M. Lokeswara Rao, to take this session. Lokeswara, please welcome.
Yeah. Thank you, Dr. Prasanna, for the brief introduction, and also thank you for giving this opportunity to interact with you all. This is a very good opportunity, and today I am going to take through the basic concepts of the intellectual property. So this may be a new topic for you all. You will not touch upon regularly, so it may confusing as well. So if you have some doubts, maybe after session we can take those questions. So first and foremost, I am not a lecturer like you all, so please bear with me. My presentation, it may not be that much good as you people do regularly. Yeah, I am taking through the main concept which I am going to touch upon is the introduction to intellectual property, and then the types of intellectual property, and next types of patent. Patent is one of the intellectual property type, and then we will also discuss about the criteria for patentability, and then what the patent contains in the patent, and all briefly we will discuss. First of all, what is intellectual property? So many people used to speak about intellectual property management, IPR and all. So what it does mean? So IP is an property exists in various forms. So what is IP? IP is a property generated by the intellectual capability of an individual or a group of individuals. That means a simple concept. Some inventions were made which you thought from your mind, or maybe a team of people who are executing some ideas to make it inventions. That is called as IP. So what is IPR then? So the IPR is the legal rights on your inventions, or the intellectual property which you are created on. So it is a simple legal rights on our own intellectual property is called the intellectual property rights. So the simple thing which inventions we are making from the ideas and all we got from our human minds are called the intellectual property, and getting the rights on those intellectual property is called as the intellectual property rights. So intellectual property having the different types or categories, in that the mainly categorized copyright and trademarks, trade secrets, geographical indications, and the patents. So these all are the major types in the intellectual property. Each one having their own acts to define what it is and how we have to get it and how we have to enforce them. So we'll touch upon slightly on each one and more elaborately on patents. So the copyright. Copyright is a form of protection provided to the authors of original works of authorship. So what it protects? It protects literary, dramatic, musical, artistic, and certain other intellectual works like movies or maybe books. Literary comes under books and all will comes under literary. So you can see in books and all there is always in the first page of the every book at the rate copyright with a particular year. So that means the book is protected under Copyright Act. So the if you wanted to get another copy of the book, you should not get the xerox of those books. So it is comes under the violation of the copyright. So if someone who having the copyright on the particular book, you come to know that some of the people or some institutions are doing some photocopies of those books, will comes under the violation of the copyright. They can file a lawsuits in the court saying that you are copying their rights. So the duration of the copyrights is in general for the author who is writing, or maybe who is taking the movies, or whoever the other, it is author's life plus 70 years. So it is a very long protected, long-term protected rights. And then trademarks. So trademarks and service marks, also called as a service marks. Any words, name, symbol, or device, or any combination used or intended to be used in commercially to identify and distinguish the goods from others. So these all are called trademark. So suppose if you wanted to sell something, maybe we can say a medicine. So you should have a different name on the particular medicine. If you take a paracetamol, there is a multiple names for the paracetamol. So those all are having their own trademarks or service marks. So suppose Dolo, we generally call it as a Dolo 650, Dolo 500. It is the original compound present in that Dolo is a paracetamol. It is a common name. The Dolo is a trademark of one of the company, pharmaceutical company, who sell the paracetamol. So it distinguishes their product from the others or maybe competitors in the same field in the market. So these are very important in the competition world, and it will be registered under the Trademarks Act on each and every country, so that it will be protected by others and not to copy these marks. So it protects the all of the logos above whatever I told, words, names, symbols, logos, banners, sound, smell, etc. Everything will be protected under trademark. So the duration of the trademark, again, it is indefinite. So every 10 years it has to be renewal. So if you don't renewal, maybe it will be lapsed, so that someone can use that. So most of the cases, maximum the trademarks will be renewed. The popular trademarks will be renewed every 10 years. So the examples of the trademarks you can see every now, the Sony, Coca-Cola, Microsoft, Bench, and many. Each company have their own trademarks. So these all are protected trademarks. So coming to geographical indication, which is referred to a geographical denomination of a country, region, or a locality which serves to designate a product originating therein, the quality or characteristics of which are due exclusively or essentially to the geographical environment, including natural and human factors. So, in simple words, we can say if the particular place where if we are growing some crop, so it gives some taste. So then it will be the own taste giving because of the soil or environment of the particular area. So that taste may not be come in other soils or in other places. So in those types, the soil, the product obtaining or the crop growing in a particular soil, you have the unique features like taste or smell or something else. So those types we can protect geographical indications. So if you take the small one example, that Darjeeling tea. So the tea leaves which are generating from the Darjeeling gives a different taste when we grow the tea leaves in separate area or in different place. So that type of uniqueness of the tea leaves are covered under the geographical indications. So these are already protected in India. Some examples are Darjeeling tea, Tirupati laddu, and these all are the geographical indications covered in our country and the countries where it is generating. So the laddu which we are getting from Tirupati is having a different taste. So as per I know, we will not get such a taste in any type of laddu which is prepared in shops or somewhere else or in maybe in some other temple and all. So the Tirupati laddu having their uniqueness. So that is the reason it was covered under the geographical indication. So then the other topic is trade secret. So the trade secrets also having the different type of intellectual property. So any information that provides economic value that is not in the public domain and that has been reasonably kept secret. So the secret, simple thing is the secret, if you keep confidential, that will become the secret. If someone knows it, then it will not be a secret. So similarly, if you wanted to maintain it confidentially and not to disclose to anyone or to the public domain, then it will be considered as a trade secrets. So this is also one of the intellectual property. So some of the trade secrets, what it protects is formulas, patterns, compilations, programs, devices, methods, techniques, or processes. The duration. There is no specific duration on these trade secrets. If you keep the secret as long as possible, that remains as a trade secret. Once if it is known to public, then it will not be a trade secret, and you will not have any rights to protect your trade secret. So the examples in this is Coca-Cola or KFC. The compositions of the Coca-Cola, how they are making the Coca-Cola product is a trade secret. So it is known only for few people in the higher hierarchy of the Coca-Cola company, and that will be manufactured. The Coca-Cola is manufactured as per the specific already a fixed formula. So that will be secret. So that is a secret. So it is a cover under the trade secret. Again, the KFC, how they are making their products is a trade secret. It is not known in public. So they are maintaining the formula is a secret. So it is also covered under the trade secret. So these two are similarly, there are many trade secrets. Even in the pharmaceutical company, pharmaceutical field also, there are some products which are considered to be a trade secrets and they will not disclose to public. So only few companies having the monopoly to prepare or to make those products and to sell their products in the markets. So they get the more revenues on that. So this is also one of the intellectual property. The next topic is the patent. So we can little elaborate on this part. So the patent, which is the mostly covered intellectual property, is maybe we can say 90% of the intellectual property is comes under the patents. So the copyrights, trademarks, geographical indications, trade secrets, and all will be the another 10%. So the major part in intellectual property is the patents. So the patents, the word is derived from a Latin word which is a patri. The meaning is lay open to public inspection. So it discloses the knowledge for the advancement of the society. In exchange, rights are granted to the innovators and rights granted are territorial. So the simple thing, so if you have an invention, if you wanted to file a patent, so what you will get and what the advantage the government will get. So you have the invention, so you have invested some money to make the invention, and you have the ideas and all you executed it to become the invention. So for this purpose, the government will give you the specific rights to practice your invention for a some duration. So for the patents, generally the duration is 20 years. So within the 20 years, you can use your invention, or you can you manufacture something, or you can sell, or you can do maybe you can give it to someone else. So the rights of the invention you generated, you have for 20 years. After 20 years, that will be in the public domain. So the public have the option to explore or to use those inventions. So it is simple. The commonly known word nowadays is a quid pro quo. So yes, so wrongly it is using nowadays. But the thing is, we are giving the some invention to the public. So with respect to that, the government is giving the rights to us for 20 years. After 20 years, that will be in the public domain, so everyone can use that invention, and they can make the products, and they can use for their own inventions. So this is the way where the inventors are getting some advantage, and also they are giving some rights, some information to the public. That way they are helping the public to enhance their knowledge. And again, so this is all other territorial, it is all territorial based. So if you file a patent in India, you will get the right only in India, so you will not able to get the right in USA or Europe. So if you wanted to protect your invention, you have the option to protect all the countries. So wherever the your invention was protected, so you will have the rights. Wherever it is not protected, it is like open to public, they can practice. So what is a patent? A patent is a set of exclusive rights granted by a state. It's a national government. State means here in national governments to an inventor or their assignee for a limited period of time in exchange for the public disclosure of an invention. So what I told, so it is a exchange program. You are giving something to public, so government is giving the something to you to use that invention for some time. After some time, it will be to open to everyone. So it is a negative right to exclude others from making, using, or selling your inventions. So patents are granted for inventions and not for discoveries. The rights. So fine, you got the patent. So what rights you will get from the patent? An Indian patent grants a right to exclude others from. The first is making and the using your invention, offering for sale. So we, and then selling the invention throughout the India, or importing the invention into the India. That means you can make your own inventions, and even you can offer to sell your invention. You have the invention, but you don't have the infrastructure. Suppose you identified one product, maybe one pharmaceutical product, but you don't have the plant, or maybe you don't have the manufacturing facilities and all to execute your inventions. So what you can do, you can sell your invention to someone who is ready to take it. So that way the patent provides the rights to sell your inventions, and the inventions what you are selling is again territorial based. You have the patent in India, you can sell the invention only in India, not in other countries. And whatever the inventions you have filed patent and granted a patent in India, you can get from the other countries the same invention, so the same product which you have invented and patented in India from the other countries. So the government will not stop you. These are the rights once the patent holder gets. So what you write, you got the patent, you have the invention, you file a patent, you got the patent. So what you can do with the patent? The patents have the attributes of the personal property, and maybe you can sell to others, or you can mortgage. That means you can give some period of time, or you can assign to someone else who is really need it, or maybe given away. That means if you have the patent, you are not practicing, and you are not giving, or you are not selling to anyone, then we can hand over our invention to the government, so that that will be open to public. So the term of the patent is 20 years. If you wish to give it to public after 10 years, you can surrender your patent to the patent office, and that can be practiced by anyone in the country. So otherwise, you can give the license, or maybe you can give the royalty. That means if you give the invention and you with your invention, somebody making some product and they are selling their product. From their product, if they are gaining some profits, you can get the royalty on the profit, maybe some percentage of the money as a form of royalty you can get from the who is commercially manufacturing and selling the products. So it may be 5%, 10%, 20%. It depends upon the deal you are making with the commercial manufacturers. So, like intellectual property, there are different types of intellectual property. In the similar way, in the patents as well, there are different types of patents. Mainly, three types of patents will be there. One is utility patents, plant patents, and design patents. So, utility patents, mainly the new processes, new machines, manufacturer, or composition of the matter, are a new and useful in improvements thereof, will comes under the utility patents. So the total pharmaceutical industry related patents, or maybe automobile industry or software industry, all related will comes under the utility patents. The term of these patents usually have the 20 years from the filing date of the patent. The second category is the plant related patents. So the cultivated or asexually reproduced plants, plant varieties reproduced by seeds are covered under these plant patents. Means some different types of plants, hybrid seeds, or something. If you are making differently from the naturally obtaining seeds and all, so those can be patented. So this is also one of the major industry, like seeds companies and all will be covered their own seeds and all under this plant patents. So the term of the plant patents again is 20 years from the filing. The third category of the patents are related to new original and ornamental designs for an articles of the manufacturer. If you are getting some design on your ornament, that designs can be patented. So similarly, designs also we can get the patent. So the term of the designs patents are 14 years from the registration. So these all are the different types of the patent, and the mostly filed patents are related to utility patents again here. So the main sectors industries are comes under the utility patents. So now we are discussed about the what is the patent, and what is the use if you have the patent, and what we can do with the patent, and then different types of patents we discuss. So now this is again I am telling about this. It is a territorial based. So in India, our Patent Act was effective from the first Patent Act was effective from the April 20, 1972, and the act was initiated in 1970. So we call it as a 1970 Patent Act, and but it was effective from the 1972. And then after there are multiple uh, amendments are made in the act. So from Jan 1995, one amendment was made, and then in 2002, another amendment was proposed, and it was effective from 2003. And in the third amendment, the most important amendment was made in the 2005. So which is effective from the Jan 1st, 2005. This amendment was earlier we don't have the patents related to products. That means if there is a pharmaceutical product, which if you wanted to patent in India before 2005, we don't have such a opportunity to file it. So only process related, or how you are making the product, or how you are preparing that product, only those you can have the option to get the patent. The other for the other there is no possibility, like compounds, there is no possibility to file the patent. So from the Jan 1st, 2005, uh, our, our patent act is completely effective, and all the types of patents are now granted. So I will give you an example. If there is a pharmaceutical product, so suppose now COVID is coming, and there are many clinical trials are going on to develop a particular product which can be used for the treatment of COVID. If some company have the if suppose developed some product, so if they file a patent, the patent will be granted to the particular company. So the particular company have the right from the filing date to 20 years to sell their drug to the Indian population for 20 years. So imagine in the current situation how much money they can generate through this. So no other company can be allowed unless until the company which has developed the new product using for the treatment of COVID-19. So the patent owner can get the complete market because of the patent he filed on the particular product. So he can only sell their invention. So they can only sell their compound. That way, our Indian Patent Act is nowadays permitting the compounds as well to protect under the Patent Act. So in the similar way, since the population is highly affected, the government also having some right in emergency time, even if the pharmaceutical company having the patent on a particular product, government also have the some rights in the emergency time. They can maybe we can say they will not ask other companies to maybe government will direct other companies to manufacture the product, since under some emergency conditions government have the right to cancel the patent and give the rights to the other companies. But this is very rarely happen. Even till now in the pharmaceutical sector, emergency was government was not opted for the emergency and giving the rights to the other companies. So now the Patent Act, which is currently going on in India, is the 2005 Amendment Patent Act. So what is the patent life cycle? So how we can file the patent, how we will get the patent and all. So this is also again a process, small process involves how to file, how to get it. So first we should have an invention, and then the invention should be drafted in a proper way to file a patent application. Then we can file a patent. So after filing a patent, it is not the way that if you file something, it will not directly grant the patent. So there is some procedure involves. So there is some examiners. So if you file a patent application, there is a procedure involving in granting the patent. So if you file a patent in a patent office, then patent office having some examiners. They will examine your patent application, whether your patent application is eligible to grant a patent or not. If they feel that the examiner feel that the patent is eligible to get the grant, then they issue the patent. So even sometimes, so examiners may overlook already known inventions or somebody filed, and examiner may not be know the same invention is already known in the public domain. So again, there is an option that the other parties, maybe other parties means even an individual who knows that this invention is not a patentable invention, and they can file an opposition at the patent office saying that this invention is not patentable. So the others, maybe the company or individual, can file their observations at patent office. So after filing the observation, examiner will review the observation and ask the applicant who filed the patent application to comment on the observation. And if you provide your response, then the examiner will, if satisfies with your response, still they can issue a patent. Once patent was granted, again there is an option for some time in India, we have a 6 months of time to others can file or maybe challenge the patent at the patent office. So the patent still examiner was not considered some of the inventions already known in the public domain, but granted the patent. So the patent should not be granted. That way, other companies or maybe here we should be a party interested in the particular sector. They can file an opposition at the patent office. So here also, if your patent is survived and you are able to get the patent, now the last thing is you have to maintain our patent. So this is all involves the money. So if you want to file a patent, you have to pay some fee in the patent office. And if you wanted to prosecute your patent, you have to pay some fee for the start the prosecution. And then once prosecution was done, examiner was granted the patent. Then if you want to maintain your patent, each year you have to pay some maintenance fee. So these fee and the money, it depends upon the inventors, the company which we are from which we are filing. Means the Indian Patent Office is dividing the applicants under different categories. If you are a MNC company, the charges will be little high. If you are a small company, the charges will be little low. And or if you are an individual, it will be very low. So I will tell you an example. So if you want to file a patent application from a particular MNC company, for filing patent from MNC company is 8,000 rupees. For a small company, it is a 4,000 rupees. For an individual, it will be 2,000 rupees. So that way, there is a clear differentiation with respect to individual or small company or MNC company. So this is all only the fee reduced is because of to encourage the startup companies, small companies, and individuals who are working on a particular inventions. So this is all the from the government side initiatives. So we know that what is patent and what is the advantage if you have the patent and what we can do with the patent, everything, and we have an invention. All we have discussed. Now everything is fine, but now what is the requirement to get the patent, or maybe criteria for patentability? What are required to get the patent? So the three major parts, major categories here is the major category should be fulfilled to get the patentability or to get the patent. So the first and foremost is the novelty. So it means maybe one by one we can further discuss on this novelty. And the second one is obviousness or inventive step. And the third one is utility or the industrial applicability. So these three criteria should match to get the patentability. So novelty. What is novelty? So novelty relates to whether something existed before its invention by the applicant or was disclosed to the public. That means if something already known in the public will not satisfy the novelty. If it should be a new one. Suppose a compound with a chlorobenzene is known. So if there is a bromo or iodobenzene is not known, then if you are identified the bromobenzene or iodobenzene, it will be comes under the new or novel compound. So then it satisfies the novelty criteria. That means the simple thing is the whatever you are patenting, it should not be exactly known in the public. So it should be new to the public. So coming to the inventiveness, so non-obviousness. A patent is denied if the subject matter of the claims would have been obvious to someone else skilled in the technical field of the invention. That means if you are inventing something, it should not be obvious to the person skilled in the particular area. So same example we will take. So if you are use the bromo in reaction and maybe obvious over a prior disclosure using the chloro. That means chlorobenzene preparation is already known. Okay? You are making the bromobenzene. So bromobenzene is now satisfied the novelty criteria. Since it is not known, we have made it. But the inventiveness criteria, it will not be matched, because who can make the chlorobenzene maybe easily make the bromobenzene. So it is an obvious to a chemistry person in the field. So that will not meet the criteria of the inventiveness. So this is also should be met if you want to get the patent. So the standards are more subjective and controversial on the inventiveness. So similar, I can explain. If you file a patent application, examiner reviewing it, in examiner point of view, because the examiner will definitely have the knowledge on the field which he is examining the application. So if he feel that it is an obvious variation, so it may not be a obvious variation to someone else in the same field. So that reason it is the standards for the this inventiveness is more subjective. Person to person it may vary. Again, if you file a patent application in India, the criteria to meet the inventiveness is different standards, and in US it will be different standards. And again, there is some controversial. So why can't it will be patentable? Because I feel that this is not a obvious variation. That way there are some controversial also there in inventiveness. So, if requirements are set very high in the inventiveness, virtually nothing is patentable. So, if requirements are set very low, all kinds will comes under the patentable invention. So, that is the reason it is more subject to the person to person. It is permissible to employ hindsight to reconstruct the invention. That means if you reverse engineering, if you do the reverse engineering, I made the bromobenzene. So bromobenzene, suppose after granting the patent, someone in the same field can simply say that making bromobenzene is very obvious to the person's skill in the art. One can make the benzene, one can simply halogenate it on the benzene, you will get the bromobenzene. How can it will be the inventiveness, how it was made the inventiveness? So that means hindsight means once after getting the patent, once after making the product, the person in the field can feel that it is easy only. So that is called hindsight. So these are little debatable things in the patentability, inventiveness, and this is a more tricky part in to get the patent in every country. So the third one is industrial applicability or utility. You have the patent, you have the invention, so you met the novelty, you met the criteria of inventiveness, so everything is fine. So to get the patentee, the invention should have the use to the public. Otherwise, it will not be useful to the public, so it will not be patentable. So the thing is, industry is a broad term including industry, agriculture, forestry, fishery, animal husbandry, communication and transportation, recreation, anything. It should be some way, it should be useful to the public. So if it is not be useful to the public, your invention will not be granted under the Patent Act. So the patent should have the public use. So the term utility is broader than the industrial applicability. So I am showing one invention which is lacking utility. So this is an umbrella. If you are making an umbrella, this is a new invention, and this will not be obviousness. It will meet the inventiveness. And coming to utility, whether this have the utility, no. So under utility section, this will be refused. So again, this is a cycle. So someone has having the new invention, invented very newly, and having the met the criteria of the inventor step. So no one is thinking about this. And then coming to utility, so it doesn't have the utility. So it will not be useful to public. This cannot be used. So the under the utility section, this will be refused. So you will not get the patent. Contents, what should be there in the patent? So the main contents, while drafting the patent, we should have all these contents in our patent application. The first one is claims, which define the scope of your protection obtained. So and then description, useful for the interpretation of the claims. So in the description, what we have to write: field of the invention, background of the invention, summary, and detailed description, examples, figures, and the abstract and title only have informative purpose. That means no legal value. From all these, the main part of the patent is the claims. So which define the scope of your protection. So if you disclose in the description 10 inventions, and if you are protecting, that means protection comes through claims. So if you are protecting only one invention in your claim, so whatever you are protecting is the only one invention you are protecting in the patent. So the remaining 9 inventions which you have disclosed in your description are not covered under the patent. So the all other 9 inventions are open to public. That means you are surrendering your other inventions to the public. So whatever the scope in the claims is only define your protection. So we should be more careful about writing the claims and getting the right claims to protect our total invention. So abstract and title is simply to know what type of invention. So suppose if it is pharmaceutical product, we will write that the process for making the paracetamol. So from this, someone can understand the title by reading the title that this is related to pharmaceutical industry. That way, just to identify your patent, the title and abstract is required. So the most critical and important part of the patent is a claims, which define our protection. So this is an US patent, which looks like this. So here the 54, which is a title, just I am showing in my cursor, and this is a patent number and the date of patent when it was granted, and the process when the application was filed, and all it will be there. And these are the similar type of inventions, but having met the criteria of the novelty, inventiveness, and the utility. But while they are prosecuting the patent or examining the patent, the examiner identified closest disclosures they will disclose here. And this is an abstract, just to know what it is. This is a simple way what related to. It gives a little more information and what it covers. And then this is the specification of the invention. So the categories: field of the invention, background of the invention, summary, and detailed description of the invention, like this. And then there are examples how to prepare the product and all. And then the most important part is claims. So these are the claims. So there is a multiple numbers that may covers under the different numbers. This is one, claim 1, a process for preparation of so and so. Then claim 2, claim 3. So this is the main protection which you are getting. So here a process for preparation of some compound, separating a diastereomeric esters of formula 4. So they are covering the separation of the 2 isomers from the specific compound. So whatever you disclose in the description and all, so the invention covers under the patent is only the process to separate the 2 enantiomers. So what can be patentable, what cannot be patentable? If you see this desktop, can you identify a patented product on this desktop? Maybe 1, 2 or 3, 4. So different were there. Maybe some LCD screen was there, telephone is there, and clips were there. So from out of all, how do you think how many can be patentable inventions? So since these all are now, everyone knows that, we know that these all are inventions. So just guess it, how many were patentable inventions in this? So these all are identified under patents, and these all were filed patents, and now it was maybe expired, so we are using these inventions, and these all are now surrendered to public. Everyone can make and everyone can use it. See how many were patented: LCD monitor, LCD stand, printer, staple remover, post-it notes, here, blinder clips, see the keyboards what support we are getting, computer mouse pad, iPhone, see, two-hole punch, stapler, phone, speaker, PC speaker. These all are their unique features and they all are granted patents before we come to know public. So after getting their patent, maybe suppose LCD monitor, some company, some Sony company filed a patent on LCD monitor. So Sony company has rewarded for 20 years to manufacture and sell their LCD monitors. And within that period, no other company can sell their LCD monitors and all. So after 20 years, every company is open to every company. So now any company can manufacture these LCD monitors. So similar way, these all are mostly are expired under expired patent. No, every company is making the these type of products. So the thing is here, what the advantage the inventor get when they are making the LCD monitor. So that was given advantage to the company 20 years. So they enjoyed and they made some money. And what is the advantage to the public? Now because they are invented, so we are enjoying the advantages of the invention after 20 years. So it like giving and getting type of thing. They are getting some money because of the invention and they are surrender to the public and public is enjoying the inventions now. So you see here patentable invention. Suppose company X has a patent one on a black and white TV. Maybe this is already expired and this is very old story. Just I am telling that expired. Suppose expired date is 2015, and the what they are claiming is a TV without mentioning black and white or anything. So what they are doing simply because the first TV which we are come to know is a black and white TV. So what they are claimed is a TV. So any TV will be covered under this claim. So coming to next patent, some company why to on a color TV. So compared to black and white TV, it met the three criteria like novelty was there because color was not known, inventive step was there because now we can see many things compared to black and white TV, colors and everything. So it was inventive. And the third one is utility is there. So public is enjoying, it is useful to the public. So the second company can get the patent on why they can get it. So what they can claim, they cannot claim the TV per se. Directly TV they cannot claim because the TV is already known. Only what they can claim is a color television they can claim it. So what they got the claim is a color TV, they got a claim company wide. So now the question is, the black and white TV patent is expiring in 2015. The color TV patent is expiring in 2020. Suppose, can company Y manufacture color TV? No, because in 2015 till 2015 the company Y should not manufacture a color TV because TV without mentioning any black and white or color is already claimed by the company X. So they need license to from the patent one or maybe company X to manufacture the color TV before expiry of the black and white TV claim. That means if you wanted to manufacture before expiry of the black and white TV, the company Y should get the license from the patent one. That means company X. So the license will not be simply given to the company Y. So they both may have some agreement. If the you want to sell suppose 1,000 TVs, so they are getting some 10 crores. So they have to pay some royalty to the company X to manufacture before expiry of the company X patent. Similarly, the company Z has the patent 3 for the TV remote. Again, this is met the 3 criteria: novelty, inventive step, and utility. So they got the patent. So company Z claim a TV remote. So they cannot claim black and white TV. They cannot claim color TV because both are already known inventions. So they can claim a a TV remote. So the TV remote, company X cannot use the remote claimed by company Z. The company Y will not use the remote which the company Z was made. So similar way, they should have some agreements. Can company X manufacture black and white TV with remote? No, need license for patent 3. Can company Y manufacture color TV with remote? No, they need the license from both patent 1 and patents 3. So the company Z can manufacture color TV with remote? No, because they should get the license from the company 1 and company 2. So similar way, what they have to do is either they have to get the license from the other one, otherwise they have to wait till that expires. Otherwise, so if you don't get the license and you are not waited till that it expires, if you are making and you are selling this, if the company 1 or company 2 knows that your invention is manufactured by someone else and they are selling, so they can file a lawsuit in the court, and they can stop the third companies to manufacture and sell their products. And again, they also get some royalty on which they made or which they are making. So there is some damages they have to pay to the company A1 and company 2. Yeah, thank you. Hope for your time. You had a good patience to listening. Almost it was 50 minutes. 50. Thank you. And if you have any questions, we can take it up. Yeah, Dr. Prasanna, we can answer if they have any questions.
So thank you, sir. Thank you, Lokeswara Rao. Participants, if you have any doubts, please post in YouTube chat box. Then sir can clarify your doubts. Please post in the YouTube chat box.
So hope you all are understood little bit, at least not completely.
No, sir. Sir. So can we wait for 1 minute, sir? If anybody want to
Sure.
there, it's
Yes.
And also the participants, feedback link will post in the YouTube chat box. Will it? For today's session. Yes, sir. Yes. Sir. Sir.
Yes, sir. Startups. Yeah, we have a Indian Patent Office website. You simply type it Indian Patent Office in the Google. You will get the Patent Office website. There is a information about how we have to proceed to file a patent application. Otherwise, there are many law firms or maybe some agents. They can help you if you reach out anyone. They can help you how to file it and how to get the patent. So the startups, the fee and all are very minimal, and the government is encouraging startups to file as many as possible, and they are encouraging the startups to do this. And in the patent office website, we also have the information about the patent agents. So there is a patent agent information. So we can see the patent agent information and we can approach any one of them and we can proceed through them. Otherwise, with the information given in the patent office website, you can directly file it. So it is not a big deal. If you have the information or inventions and all, we have to approach either patent agent or the help documents given in the patent office website. We can go through that and we can file a patent application.
Sir.
And data is the 6 GB also 51.
Yes, sir. Yes, yes, sir. No queries, sir. No queries so far, sir. Okay, sir. Thank you, sir. Thank you, Lokeswara Garu. On behalf of our management of Sri Venkateswara Group of Colleges, Director
I
of
think
IAS,
the session was very useful, Lokesh Garu, and I'm pretty sure that this will throw some light on the IP rights, and in fact, there were some chat comments about asking for the PPT if you can share, and I think the
Okay,
organizers.
I will look into that.
Yeah, sure, sir. Thank you.
Yeah.
Sir, one more
Yeah,
question,
thank
sir.
you.
Sir,
Thank you,
sir,
Prasanna.
Lokeswara Garu, one question, sir. When we can patent our compound? One participant asked, when we can
So,
patent our compound?
yeah, see, as long as if your invention is, if you identify some invention, you have to file as early as possible. So, otherwise, if it is coming to public domain, so someone can also file your invention. So, the thing is, if you have some idea and if you have some invention which you are aware, so as early as possible, you have to file it. So, there is a window also again. If you file your invention and within 1 year we can add some additional information to your invention and you can file the complete application. So the patent office provide you some time to add the additional information to your the initial invention and you make it complete and then you can file the complete application. We have a window of 1 year time for this filing complete application. So the thing is, if you have the invention, you have to file as early as possible. That is the um, uh, thing. Maybe we can propose to the inventors. That is a
Sir,
suggestion we can say.
sir, when we can patent after writing thesis or before it?
Before it only, we see if you file the thesis, maybe suppose if you got the thesis or maybe journal article. So within 1 year, if you don't file a patent application, your own journal article will become a prior art for your patent application. That means it is already known in the public domain. You will not get a patent. So we have a window of 1 year time, so that if you wanted to publish or if you wanted to add your information in your thesis, you should file before or at least within 1 year from the public. It is known in the public domain. Otherwise, it will not be patentable.
Okay. So, thank you, sir. Thank you so much for your nice session, sir. Thank you very much.
Yeah.
And dear participants,
Thank you.
sir. And dear participants, tomorrow we will meet at 10
Yeah.
a.m. again. So, thank you, sir. Thank you so much.
Okay. Okay. Thank you. Yeah.
you.